No, ma'am, I did not. I gave you.
Sir, do not interrupt me.
Yes.
Yes, sir. So you are set for hearing on your motion for new trial. I'm going to go ahead and take all of the defendants who are set for the 6 p.m. contest docket. Once I take those, then we will have your hearing. All right. So
That's fine.
okay, go ahead and just go and stay logged in right now. All right. All right. And now we will have the hearing on the motion for new trial. Let me get that paperwork in front of me. Mr. Haynes, if you'll please unmute. Case numbers G 505-4601 and 02. Style the State of Texas versus Vincent Lewis Haynes. At jury trial on November 13th, the jury found the defendant guilty of both charges and assessed punishment. The defendant filed a motion for a new trial and requested a hearing. And the state has filed a response to the defendant's motion for new trial. And Mr. Haynes, you received a copy of that response, correct?
Correct.
Okay. All right. So, Mr. Haynes, this is your motion. I'll let you go ahead and summarize your argument for the court.
Can I find out if is this a court of record?
Yes, sir. We're a court of record. As I said at the start of every one of these hearings, that everything is on the record, everything is being recorded and streamed live as required by statute. And if when you had your jury trial, you were given the little pamphlet of information about how to appeal, and that's an appeal from a municipal court of record.
Okay. Okay. I am a natural born living man, and I grant the court's permission to use my name for future return of my equity. I am not a corporate entity. Do you want me to present something in particular, Your Honor?
Sir, you have filed a motion for new trial, and I'm giving an opportunity to summarize your argument. Then the state may make their response, and then I'm going to rule. So summarize your argument for the court as to why you should receive a new trial.
Okay. I can only point to several facts. Number one, there was no one in the trial that was identified as an injured party. There's no way for me to make amends for whatever offenses the offended party would have against me. And any claims that the prosecutor may have or willed against me, I would like to know if he was doing so under the penalty of perjury. I also, basically, I am trying to make sure that the court knows that I appeared in trial only under special appearance so that I can get the facts and get any presumptions about my name and the use of my name correct.
Sir, I'm going to pause right there. You were not granted any sort of special appearance. You appeared as the defendant charged in a case.
No, ma'am, I did not.
Sir, do not interrupt me. The complaint was read to you. You entered a plea, and you were not given any sort of special appearance. And this is not information that is included in the motion for new trial that you filed. So this is not an argument that you included there as I have read it. So you need to be summarizing your argument that you in your motion for new trial that you have filed. This is your time to make your argument regarding that motion. This is not a time to raise new issues that were not.
It's not a new issue. When I told you I am a natural living person, and that even in your chambers, I did not identify with the all caps, in which you said that's only for reading purposes, and I vehemently objected and I opposed that because I don't want the presumption to go forth. So that is a part of the motion. That is a part of why the request of a new trial is.
All right, continue with your summation.
Okay, so in order for any presumption or any assumption of me being a corporate entity where the court may see, and maybe the court may not see, that I'm not a corporate entity and that I can settle and close this matter because the court should be able to identify the court's fiduciary responsibility and allow for this claim to be verified and settled on the record.
All right, is that the summary of your argument?
I mean, couple that with, like I said, there was no person in the courtroom that identified me as offending them or violating any laws.
All right, response, Mr. Bishop?
Yes, Your Honor. The defendant's motion essentially states, and I hope I'm summarizing this correctly, that he feels like his constitutional rights were violated because he did not receive due process. And I've pointed the court in my motion or my response the fact that he did receive due process. He had a jury trial. He had the right to face the officer, and incidentally, the officer is the one who would be testifying under penalties of perjury. The prosecutor did not testify. I'm not a witness. The officer would testify under penalties of perjury, and he did testify. Defendant had a right to cross-examine him. It was a jury trial in front of a 6-person jury, which is the number of jurors in a misdemeanor case, and these were Class C misdemeanors. And so the defendant would not be entitled to a 12-person jury unless he was in district court, which is not the case. These are not felonies. They would not be, these are Class C misdemeanors. And so the state would point to the fact that he had a jury trial. He had a right to cross-examine the officer. The officer testified under penalties of perjury. And the jury found the defendant guilty on both offenses. And there's been no other error identified by the defendant that would warrant this court granting him a new trial.
I object.
Sir, hang on, Mr. Haynes. Go ahead, Mr. Bishop. You may have you finished?
That's all that I have, Your Honor.
Mr. Haynes.
I object.
Sir, hang on, Mr. Haynes. Go ahead, Mr. Bishop. You may have you finished?
That's all that I have, Your Honor.
Mr. Haynes, you have you may state your objection.
Okay, I object because he's saying that the officer is the one that is testifying. The officer is a peace officer. The officer did not testify as to me hurting him. There was no one in the courtroom that identified me as offending them. The case is not against the officer. The case is the state of Texas, and the state of Texas was not in the room. I didn't see that person in the room. But the constitutional issue is I have a right to face my accuser, and there's no accuser that was identified in the room.
All right.
Therefore, due process is a part of the guarantees under the Constitution.
All right. Thank you very much. All right. The court has read and reviewed the defendant's motion for new trial with attachments and the state's response to the defendant's motion for new trial, and has heard the argument here during this hearing. This is also the same court that presided at both the pretrial hearing and the trial. I'm noting for the record that the defendant, Mr. Vincent Lewis Haynes, was advised several times that these are criminal charges which carry criminal penalties. As the defendant continues to refer to civil matters or civil approaches such as injured parties, fiduciary responsibilities, and making some sort of amends, almost as though it were a restitution. And though this is a criminal case, as the defendant was advised on multiple times during multiple court appearances, The Texas Code of Criminal Procedure, not the Texas Rules of Civil Procedure, control in a criminal court such as this. And under the Texas Code of Criminal Procedure, the defendant did receive a fair jury trial as required by the Texas Code of Criminal Procedure and the Texas rules. The defendant received a 6-person jury trial and was given the opportunity to hear the officer testify. The officer was the accusing witness. The defendant was given the right to confront the accusing witness and to cross-examine the officer. Therefore, the court is denying the defendant's motion for new trial.
Your Honor,
Yes.
Your Honor, even now, you've never really conferred jurisdiction. You've never really established. I question the jurisdiction. I've done all I can to get you, the court, to understand that I'm a natural living person. I'm a live breathing person. I'm not an artificial person.
Mr. Haynes, I understand that every defendant that appears in this court is a natural living person. And this court has jurisdiction granted by the state of Texas and the city of Dalworthing Gardens, and that has been explained to you previously at previous appearances. And once again, we went over that in the court's chambers the morning of your trial. If you still question whether that the court has jurisdiction, you might question it, but the statutes, the state laws, and the city ordinances are very clear, and this court has jurisdiction over criminal charges alleged to have occurred within the city and the territorial limits of Dalworthing Gardens. You are charged with committing 2 Class C misdemeanors within the territorial limits of the city of Dalworthing Gardens. Therefore, this court had criminal jurisdiction over your cases. The court has denied your motion for new trial. You do have a right to appeal if you wish to appeal. You will need to file a written notice of appeal. You will need to file an appeal bond, which is double the amount of your fines and costs, and you'll be required to put down a deposit for the transcription of the record. And you may do that. You received the pamphlet earlier, which gave you some general information regarding the timelines. So you need to make sure that you follow the rules in regards to perfecting an appeal if you wish to do so. If not, you will need to pay your fines and costs.
Your Honor, can I ask the court a question? Do you have all the records from all of the proceedings that I've been involved in with the court?
The court does, yes. Yes.
Okay. Okay. I just wanted to make sure, because I submitted to the court a form of a bond and a non-negotiable money order, postal money order for $21.
You filed a $21 cash bond on August 6th.
Okay, do you still have that?
Yes.
Okay, all right, thank you.
And you may use that as a down payment if you wish to use that to start making payments on your fines and costs.
I can use that, ma'am, the best way I can. I'll direct the court on how that can be used.
Well, it will either be remitted to you or applied to your fines and costs. If you pay this in full in another way, that would be remitted to you. All right, make sure that you refer to the appropriate time limits regarding a motion, any sort of appeal if you wish to do so. You have 10 days to get this paid in full.
I will file a motion to appeal, but I can also verbally tell you that I'm going to appeal. So as
you have to file a written notice of appeal advising me will not.
I will file it, but the instructions also said that I can verbally say that I can appeal as well.
You may tell the court, but you do need to file a written notice of appeal. And you must post your appeal bond to perfect the appeal. And that is double the amount of the fines and costs. All right. This concludes your hearing. You are released at this time.
And then let's see, George Redden. Do I have George? Why don't you come on up and have a seat, Mr. Redden? And then This is your request for an order against an Andrea Paragus
Yes.
under case 25-417.
Yes.
So there's another hearing scheduled that seems to have something to do with this too on the 15th. There's not a basis under the law at this stage to issue an order, but I'm going to set this for hearing. December 15th, you'll be back. I'm not going to argue with you, sir. This is the decision of the court.
Something. Someone
It's the
being
decision of
wasted
the
drunk
court.
can get in your face, and that's okay.
It's not okay, but it's not defined as unlawful harassment, is what I'm telling you. But
Wow.
sir, stop. You have a hearing on December 15th. If there's more information that you need to supply to the court, that's the time to do it. We're going to hear from both sides and find whether there's an emergency. Today, I don't find that there's an emergency, which is what I have to find under the law to issue a temporary restraining order without the person knowing it's happening. So December 15th, there's a hearing, 9 o'clock, expect to spend the morning, and you can present all that information to the judge at that point. And then we'll see after we hear from both sides if the court can issue an order.
Just so I can understand clearly, if I was to go behind a bar,
So
off
I'm
the clock,
not,
being
I'm
wasted,
telling you what you wrote down is not sufficient. If there's more information, get it written down, get it into the court. Court will review that and we'll all talk about it again on the 15th
You did
or
review
put you under
everything.
oath. Yep.
and none
Everything
of
you
that's
sent.
sufficient.
So do you want a hearing on the 15th to talk more about this with both sides present so we can make a decision or not?
I just think I'm going to get more backlash because I'm doing this. Didn't even want to be here today. I didn't want to have to put in the work of all that I've gone through.
Well,
It's
December
insanity that I've
15th,
dealt
there's a
with.
hearing with that other person. I think that there's an order and we can set this all on that day and hear from all parties.
I'm not trying to argue with you. You have to understand my health has been affected. I don't sleep.
understand what you're saying.
I'm teetering on suicide because I can't just quit my job and I don't know how to get this to stop. All the harassment I'm dealing with.
So shall I set a hearing and we can?
Sure.
Okay,
I'm just
so
blown away
December
that
15th.
everything I wrote wasn't good enough.
So the next step is the civil department where you started. They're going to give you something called a service packet. All of that has to go to Andrea Paragus.
Right. I have to
Not
have
by
them-
you, you know how.
Yeah, the last one was given to me. I have to get somebody to sign and they have to serve her
Yeah.
the papers.
Law enforcement will do it. There's businesses that'll do it. Family or friend who will not be called to testify. They can do it. And exactly that. They need to file a document with us either on that day or before that tells us what they did so that the
I'm
other
just
side has notice. So we
Blown
can have a
away that
hearing.
what I submitted is not
I
enough.
understand. People, I mean, you can feel harassed and that's fair. But the way the state leg is defined unlawful harassment is different.
Well, what is
So-
that definition? Can you please, so I can know?
Look through the petition. There's actually the laws included in that petition.
I mean,
But I have a
everything-
whole calendar here that's already scheduled I need to get to.
Yeah.
But
Fair.
December 15th, we're going to be back and we're going to take it up. But look back at what you filed. The laws included in that petition for you.
Well, the things I wrote fall under those guidelines. I don't understand why it doesn't count.
Yeah. All right. So we'll see you on the 15th and we can take it up with both sides.
Oh, thank you. Oh, one last thing.
Yep.
If I decide not to serve them and just let it all go, what happens then?
Nothing. We just strike the hearing because you won't be there.
Okay, thank you.
All right. Thank you.